Delighted to have all of you here for our first Friday monthly meetings of City Club that we've reinitiated. And it is certainly my honor and the honor of City Club to have Attorney General Dan Rayfield and former Oregon Supreme Court Justice Thomas Balmer join us. Help me welcome them. Attorney General Rayfield and Justice Balmer will discuss the many federal lawsuits that Oregon has joined, challenging the president's executive orders and other contracts. You know you're proud of it. Okay, that's good information to have. And other matters that the federal government has taken. And one key case in which Attorney General Rayfield is lead counsel, and another that the Ninth Circuit addressed just 2 days ago in a decision that it released. Before we begin, could I have everyone silence your cell phones? Thank you. Now, a word about City Club. City Club's mission is to inform our members and the community in public matters, leading them to appreciate the responsibilities of citizenship. We accomplish through research, through forums like this, and producing nonpartisan events that inform our community and our members about public policy and elections. City Club is committed to providing a space for civic dialogue that encourages respectful discussion and positive dialogue. And it is the City Club members who provide the ideas, lead the conversations, perform the research, and plan programs to address important issues to our community like the one we're at today. For developing this program, I want to give a special thanks to Kayla Kinnett, our Director of Communications, and to Sam, thank you, and to Sam Meth and Shoshana Baird, who are on our program committee that have attended to all the details here. Now let's take a moment to thank our sponsors for this program today. The Miller, Nash, and Tonkon law firms made this possible through their donations, and they're represented here by their lawyers. Let's give them. We also want to thank our season sponsors, AARP Oregon and Fight Against Sex Trafficking, for their support. Now on to today's program. Oregon Attorney General Dan Rayfield has joined and initiated an unprecedented number of lawsuits and filed Amikas briefs against various federal agencies and in some cases against the president himself. I wasn't expecting applause. The U.S. has never seen before the number of cases that challenge actions and inactions of a federal government. But these cases raise fundamental questions about our government, including the limits on executive authority, the separation of powers between Congress and the executive branch, the separation of powers between states and the federal government, and certainly the extent of the fundamental protections our Constitution gives for our rights. Now, before he elected Oregon Attorney General in 2024, Mr. Rayfield represented District 16 and was Speaker of the Oregon House. Before that, in his legal practice, he represented consumer protection cases. Justice Balmer served on the Oregon Supreme Court for over 20 years, 6 of them as Chief Justice. Before his appointment to the Supreme Court, he served as Oregon's Deputy Attorney General and in the Antitrust Division of the United States Department of Justice, and has argued before the United States Supreme Court. And I've just learned that before going on the bench, Justice Balmer was a member of City Club. And we're grateful to have these two distinguished lawyers join us here this afternoon. Some of the registrants for this program have submitted questions, and Justice Balmer may include some of those questions in his program today. After the discussion, we're going to have an opportunity to ask questions live, and that opportunity will be a privilege of City Club membership. So we'll invite members to the microphone to ask those questions. Now, gentlemen, the floor is yours.
Thanks, John. I want to start with a little background. I think it's worth pointing out that Oregon was one of the very first states to bring legal challenges against actions taken by the Trump administration. You'll recall the president was sworn in on January 20th, and that day he signed an executive order asserting that claims to birthright citizenship based on the 14th Amendment were invalid. The next day, Oregon and 3 other states filed the first case challenging that executive order. They filed in Seattle, and they quickly won there, and that set the stage for a U.S. Supreme Court decision that we'll talk about later. And it seems like it's been one case after another since then. Dan, we want to talk about that and some other specific cases, but maybe you could first give us an overview of how many cases Oregon's involved in now and how you decide which cases to participate in with attorneys general from other states.
Yeah, and thank you for being here, everybody, on a Friday lunch.
In July.
So we appreciate this. Also to talk about law, and what we hope to be will be informative, but also probably a little bit more in the weeds than you get if you're reading the newspaper as well. And so I think it's probably good to take a step back and think about, you get elected into this position in November prior to coming into the role. I came into the role at the very beginning of the year. And in less than a month, right, we are filing our first lawsuit against the Trump administration. So there's a couple of things I want you to pick up about that, is the coordination and the collaboration between attorneys general across this country. Before I had even taken office, we had already been meeting, talking about a lot of the things that were going on. And we had a presidential candidate at the time that was talking very openly about some of the things that they wanted to do. So it made it very easy to plan on the front end about, hey, what you're talking about on the campaign trail is kind of unconstitutional. And if you want to do that, we're going to do the front work to be prepared for that. And the reason we were is because he was talking about delivering on those issues. So I think that's really important to note, that there was a incredible amount of collaboration moving into the space among attorneys general across the country. And then the other important thing to note, you had people at the Department of Justice here in Oregon, frontline attorneys already working on these issues, working to protect Oregonians in that space, which made it very easy. And then I was very fortunate to assume office on, it was the very beginning of the year, so January 1st, and have a little bit of foot traffic before we had to file our first lawsuit. And the decision to file a lawsuit in a context like that is pretty simple, and this is kind of the analysis we give for all the different lawsuits. First, we have to say to ourselves, is Oregon or Oregonians being harmed by the actions that are going on in Washington, D.C.? If the answer to that is yes, then you start moving down to the next part of the analysis. Is the cause of that harm due to something that is unconstitutional or a violation of a law? And are we, as a state, the right folks to bring the lawsuit moving forward? If the answers to those questions are yes, then you absolutely must move forward in this role as Oregon Department of Justice, because we are in the rule of law, of enforcing the rule of law, and frankly, enforcing the values of Oregonians and bringing your voices to light in the courtroom. Now, not always are we the right party to bring the lawsuit. And so in this analysis, I might answer to yes to all of those questions. Oregonians are being harmed. It's the result of an unconstitutional action. But we, as the state of Oregon, are not the right party to bring that forward. So we will sometimes partner with other organizations, and you heard that talked about. We'll file the Amikas brief in support of other things that are going on, again, to lend credibility to the voices of Oregonians in those cases.
And let me just add a footnote there. In some ways, you're following on Attorney General Ellen Rosenblum, who filed a number of cases against actions by the first Trump administration, and the Democratic aid attorneys general had been working together from then on. You had folks who were experienced in bringing these kinds of cases, which is great. Now, do you look at the dollar impact on Oregon for some of these cases, or do you look at the possible interference with constitutional rights of Oregonians, whether it's choice or discrimination based on various factors?
Absolutely, and I think in a broader context, and for those that are kind of keeping track, we have 33 lawsuits currently filed as the state of Oregon. You think about that. Thank you. Our president loves to employ lawyers, so I guess we thank him for that. But in this general context, you think about that: 33 lawsuits. How many months are we into the Trump presidency? Right? We're 6 months into the Trump presidency. So take a little bit of step back going to 2016. At this point in time, there was roughly only 3 lawsuits filed against the Trump administration. So the actions that are going on right now are incredibly unprecedented, and I think probably over 20 years we've seen more presidents, Democrats and Republican presidents, really start to overstep their bounds in the executive authority role. And so attorneys general's role, whether they're Republicans or Democrats, have seen this increased activity in terms of enforcing the law. And as we're thinking about the impacts, so directly to your question, what is the harm to the state? We work with our state agencies to really understand that. And right now, Oregon's involved, those 33 cases, is protecting more than about $3.3 billion of money that otherwise would come into this state, but for the actions of the Trump administration. And then you also get into the other thing where rights are being impacted, which is kind of another separate category that we're really looking at.
There are a number of different categories that I think we ought to talk about. But could you take us inside the discussions within the Democratic Attorney General Association about who's going to be the lead state on some of these? Where is it going to be filed? How are those decisions made?
And before we do that, I want to take them, pull the curtain down on the discussion that you and I had in an email 2 days ago. The Chief Justice sent me this email, and he said, Dan, are you going to wear a tie? And I read between the lines, right? He's retired. He doesn't want to wear a tie.
I can't remember how to tie a tie.
I just want to really address that fact that we're here, because of him. And I know a lot of you are trying to ask the question, like, it's like, as a judge, how many times, because 20 years as a judge, right?
Yeah.
How many times when you were in that rub were you wearing shorts?
Once we went to Zoom, very often.
Okay, all right. So I just wanted to clear that up.
Rarely in person.
Yeah. But so back to more of the question. How are we deciding how to lead in this? What we knew is that what was coming from the federal government was overwhelming in the scope of work, right? So not one single Department of Justice across this country was going to be able to handle that workload. So we knew we had to collaborate. We knew we had to partner together in this workload, which then brings the ultimate question: where do the cases come from? You have a collective of lawyers thinking about these things. We have lawyers in our Department of Justice. Prior to the election, we had kind of divvied up some of the workload. We knew that certain states were going to work on birthright citizenship. We knew that there were potential funding freezes and different states were going to work in those areas. So we'd really kind of choreographed that. Then there were emerging issues. The extent to which that tariffs were going to be used and the manner in which they were being used was not something I think many of us anticipated. In the state of Oregon, we have been working on that internally, and so we had a lot of groundwork done on that, and so we led on those states. So it's very collaborative conversations that we have. It's resource allocation, and it's a lot of partnerships.
You have some terrific lawyers at the Oregon Department of Justice, but you have limited resources, and most of your lawyers are advising state agencies and commissions, and they're handling the state's civil and criminal cases. How many lawyers can you devote to these sorts of lawsuits?
So it's an incredibly good question, and we have if you think about the Department of Justice, we have over 1,600 employees. I think we'll be close to 1,700 employees after this last legislative session. So one of the things when I came into office, we really wanted to create infrastructure for this work, because that did not exist prior to coming into the office. So the first thing we did was we created a Federal Oversight and Accountability Cabinet, and we did that before I even took...
About how many lawyers do you have?
Oh, so we have a little more than 400 now. Okay. So when we're fully staffed up. And so in this, we created a cabinet to really create what I would say is communication among non-traditional governmental partners to be able to get into community, understand what's going on. And then we had to create the infrastructure within the organization. And so we actually created a sub-unit within, or a subsection within, our trial division that really focuses on this federal oversight and accountability. In the interim, right, because that gets done through this legislative process, in the interim, we were really borrowing work from your trial division,
Right.
your appellate division, your general counsel division, and to the Chief Justice's point, we have amazing people, not only attorneys, staff members that do the work that really get this done. And I will tell you that folks inside our Oregon Department of Justice were working harder and more than they ever have to protect all Oregonians. And we would not have the state we have today or not be leading in the cases we have today without their work.
So how do you decide where to file a case, and how many cases have been filed in Oregon? I know that some have, and we'll talk about some of the cases that you've taken the lead on. But how do the AGs say, is there a better judge here? Are we forum shopping in part, which is perfectly legitimate when you're trying to get to a particular result and have options? How do you make those decisions as a group?
So the first thing you have to do is you got to figure out who's joined the case, right? So as you see some of these cases, the one thing you'll note is not every state joins all the cases, and that's for various reasons. Sometimes the states aren't harmed the same way, right? So eventually, if we think about the actions of the Planned Parenthood lawsuit that was filed back east by Planned Parenthood, that injunction impacted some states but not others, right? So right now in Planned Parenthood, there's a freeze on the funding going out to Planned Parenthood that CCOs have put on. So every state's impacted differently, so different states join. So that first analysis is you only can file where you have a state that is a participant in that lawsuit. And so we start from that analysis, then you start looking at who are the lead attorneys and who's the lead Department of Justice filing these cases. Sometimes there's specialty courts. So in the trade case that we have filed, that needed to be filed in New York. And then we start working through that analysis. And you know this, there are certain judges and certain circuits that are a little bit more experienced or have a depth of knowledge in certain areas. That plays into how you might make those decisions. But often it's really driven by a lot of the lead plaintiffs and where they are situated across the country. Because a lot of these cases we do anticipate are going to make their way to the Supreme Court.
Right. Are there any cases, what are some cases that you decided not to join, where other states said, we're going to go do this case, and you say, that doesn't impact Oregon enough, we'll file an Amikas brief or maybe not participate at all because it doesn't affect us that much?
Yeah, and I'll take that in two camp points.
Yeah.
Some of them are funding cases, right? Where we look at the funding coming into Oregon and we say, oh, shoot, this just doesn't impact us. Now, the interesting dynamic of that is all of us in the populace in Oregon don't necessarily understand that. So sometimes we get these emails, why the heck didn't you join that? And it's like, boy, you're not fighting hard enough for us. And it was like, no, there's a rational reason why we didn't join. Let us explain that. So you have situations like that where we haven't been harmed. And then some of the other ones are, again, we don't have standing. And so there are cases where the Trump administration was trying to roll back labor protections for federal employees. We examined that and thought, are we the strongest? And we could have made an argument for standing in that case, right? That we could bring the case. But frankly, it just wasn't a very strong standing argument, and the best people to bring it were the actual employees who were being impacted by those decisions. So we made the decision to stay out, and then we supported it via an amicus brief.
Right. Have you ever not joined cases because you didn't think they were that strong legally?
So this is an interesting conversation that comes up pretty frequently, where we're talking about, you look at the makeup of a court, right? And what we determine as a strong case is often determined by some of the judges that hold those positions and their philosophical viewpoints. And so what we're trying, and what was a strong case maybe 20 years ago may not be viewed necessarily as a strong case now. And so the way we're operating is trying to be values focused on Oregonians. And if we have arguments that our lawyers feel comfortable with and that I feel comfortable with, that we can make them in court and advance the values of Oregonians, we're going to do that. And there are going to be times, right, where we look at that and say, there's a possibility we could lose this, but if it is the right thing to do and we have proper legal arguments to make and we have standing, we're going to advance those values forward. I think we're at a point in our democracy right now where you can sit and be quiet. And there's a tremendous amount of pressure from a president who wants to intimidate us to be quiet. And I think people in elected offices right now, I think all of us have an obligation in our community as elected officials to stand up and push back when we have that moral ground and that sound logic to do so. And that's been our approach.
I think that's a great question. Actually, I'm going to go from that to a question that was asked by several of the registrants here when they registered and were able to submit a question. And some people said, what can individuals and small groups do to respond to the government's attempts to dismantle and defund critical government and government-funded programs?
I just go back to how we think about, how were we taught about democracy, right? Democracy is about participation. It's about involvement from everyone in community. And then I think about what's been going on over the last 6 months. A lot of these decisions, I talk about this a lot, these are decisions that were supposed to be made in public. These funding decisions, and often they were initially made in public, which is why we have a lawsuit, right? There's a law that says you need to fund this. Government says, no, we're going to ignore that law. That's why a lawsuit exists. But these decisions sometimes that are being made in this administration are being made in the dark without our input. And so I think we have an obligation in our own unique ways to speak out and provide that public input to let the federal government know that this is not the direction that we want our country to go. This is not the country that we want to live in if this decision is, opposed to our views in that standpoint. That's the obligation I think we have in a democracy to do that, which is very difficult depending on where we are in life. If you are a parent, right, and you're trying to figure out what am I going to put on the food for dinner in the evening, right? You're trying to figure out, do I need to go to the store after I get off work? You're tired and you're getting home. Shoot, this happens to us all the time, right? We're struggling to figure out what we're going to eat. And so I think we're so busy with these other things in our lives, and how do we take time out of our busy schedules to invest in our democracy and make sure that our voices are being heard? And I think right now in this moment in history, people are doing that more than they ever have. But here's the thing, and this is the thing that frustrates me about democracy and things. I often think about water. This is weird. Why do you think about water? We never talk about water. Why don't we talk about water? Because it's boring. Right? Like, it's incredibly boring. I tried to write an op-ed one time on water, and it took me 2 months to make it. I was like, no one's going to read this. And water only becomes important when there's a crisis, because it's essential. And democracy is very similar, and we've reached this crisis point, and now people are talking. The question is, how do you have a continual investment in our democracy? It's like a relationship. You have to continually invest in that relationship. You can't just selectively do it every 2 years when we reach a crisis point. And that's kind of how I feel where we are right now.
That's a great answer. I appreciate that. Let's look at another strategy issue that comes up. There may be some times where you don't want to take a case to the Supreme Court, and this is sort of strategy for different AGs, and different people may think about it differently, but there certainly have been people, and one of the ones that stands out and is now up for debate among transgender advocates and transgender care advocates. Do you really want to take a case like this to the U.S. Supreme Court at this time, set a bad precedent? Is there a risk in some of the positions you're taking in some of these cases that we're going to end up with bad precedents, and people look back to the Civil Rights Movement and how Thurgood Marshall carefully planned this out, how we're going to get to Brown, how we're going to get other cases, and Ruth Bader Ginsburg plotted for a long time how we're going to have better gender equity if we bring this case and not that case. Do folks talk about that among the AGs?
Yeah, those things are always talked about, and for the lawyers in the room, we always talk about that, right? Is this the right facts to bring the case forward, right? Is this the right case to kind of make that point? A lot of the things that we're doing right now, you'll hear this is about funding, or you hear this is about tariffs, or this is about gender-affirming care, whatever the host of the issues are. But really the foundational things going on in all these cases really involve foundational democracy principles. And so that's a lot of the way that we're thinking about some of these things. But you also know that there's, the court kind of tips its hand, right? The universal injunction orders, it's not like that caught people by surprise as we were moving forward. And those were conversations. Could this be a risk? Of course it is. But other people are also bringing cases as well. And so you might think about, we talk about the tariffs case. There were private side tariffs case moving at the same time that there was the state of Oregon tariffs case. So you're operating in an ecosystem, and we are not the sole actors within a legal system.
Right. Other people can bring those cases, and even if you said this is not a good time to bring this case, they go ahead and do it, and you're going to file an Amikas brief saying we support them, even though you think this is not going to it's not going to turn out well for us.
You're off to the races. A lot of those
cases, you know how they're going to play out. Have any Republican attorneys general joined the Democratic attorneys general in any of these cases?
Not yet. And I think the You know, we hold out.
Just looking for the right
this
case.
This is a real thing. We get emails coming into our office. Hey, could you work on getting some Republicans to join your lawsuits? And then we joke, well, you know, like I guess I could start making calls. I'm pretty sure I know the answer, but I think it is also illustrative of the issue we have in society. That question should also be asked in the inverse order. When Biden was president, how many Democratic attorneys general were joining the Republican cases to curb executive power in the same way, right? Similar principles that are going on right now. And you know what? Some of those Republican cases were successful. So I think we got to look at it both ways. And then you say, well, why is that going on in society right now? Well, you have politicians on both sides that are worried about their base, right? And I think this is a problem you see in Congress. People are so scared of their next primary. They don't like what's going on, but they do not have the confidence, the electoral confidence, to then be able to go out and say what they really believe. And that is a systemic problem in our democracy right now. And it's a problem with Democrats, and it's a problem with Republicans. And I think societally we have to look at that foundationally as a democracy, is how do we systemically fix that issue so that we have people supporting the folks that they were elected to represent and the merits of the issues that are before them in the moment, and not cowering to a minority of the base in either party. Wow.
Okay. Well, let's talk about the birthright citizenship case a little bit. You folks won, and most of the lower courts, I think all the lower courts that looked at this said the executive order is unconstitutional. The 14th Amendment provides birthright citizenship to virtually every person born in the United States. The Supreme Court takes the case and they reverse and vacate it on a procedural ground. Where do we go from there? Explain. Not everybody is a lawyer here, although everybody is very well read here, because I know the City Club audiences. So we talk at a level of sophistication that is not possible before lots of other audiences. Where does that case go from here? And talk a little bit about their decision on the nationwide injunctions.
Yeah. Wow, how much time do we have?
Well, we can do a 3-day seminar on this topic.
Yeah. We can start advertising it now. I think the one thing to note, the birthright citizenship case was one of the most clear-cut cases that I think we as Democratic Attorneys General really started to look at and bring. Again, this was the first lawsuit we filed, and it was incredibly quick that a judge appointed by Reagan quickly ruled, hey, how do you as lawyers for the federal government stand here with a straight face today and make these arguments? And they implemented a nationwide injunction which says, hey, you got to halt this executive order. And that's for states that weren't a part of this lawsuit, right? And so it was across the nation. Supreme Court eventually said, hey, we've got issues with this kind of universal injunction just going across the entire country. There was kind of moved that back. However, a lot of press was given to that. There are avenues that they set forth in that decision that you still can get a universal injunction. In fact, when that got reversed, the very next day or within hours, ACLU had filed a new case. It was a class action case because none of this was really new. We kind of had the feeling that the Supreme Court was trending in this direction anyway. And for those, if we're going to play and be fair to both sides, right, when President Biden, a Democrat, was in office, people were criticizing universal injunctions at that time on the Democratic side. So we just need to,
What's interesting, though, about this one, and I looked at that too, and President Obama too, and both Biden and Obama asked the Supreme Court to take that issue and get rid of, or at least limit, the scope of nationwide injunctions, and the Supreme Court never did it. Yeah. Here, this administration asked the Supreme Court to decide that issue, and they say, oh, yeah, as a matter of fact, you can't bring these sorts of cases. Yeah. But you're going to win anyhow, right?
Right, that's right. So there, it's an incredibly strong case that we have. And so in this dynamic, right, these are the ways that the courts are weighing what's their procedural role for the courts to play in disputes that we have in society, right? That's ultimately what's going on here. Right. It comes back to the Ninth Circuit, and 2 days ago, we actually got back to a universal injunction on the exact same case. We got a ruling on the merits. And then, as we talked about a lot of these cases, whether you're in a good district or a bad district, depending on the issue, however you conceptualize that, and a lot of attorneys disagree on that, by the way. Eventually, cases like this are definitely going to be appealed to the Supreme Court.
Yeah. Yeah, and then you're going to win that. There's no thoughtful commentator who thinks you're going to lose that case.
This is getting back to that other party issue, right? Like,
Right.
I walked through the legislature at one point, and a lot of people were gathered around, and some Republican folks came up to me and it's like, "Boy, that's a loser case that the administration is bringing," right? So even within their own party, right, people are going, "Yikes, maybe not our best foot forward."
Right.
So the real question is Trump thinking about what cases they want to be engaged in and the bad case law they're taking?
Right.
I'm going to, spoiler alert, I don't think they are.
No comment. Here's another question that was raised by some of the registrants. Not everybody in the state voted for you. There are taxpayers who may be questioning whether limited state resources ought to be used to trying to stop the actions of the Trump administration. What do you say to those folks?
Well, it hurt my feelings. I thought I was going to do really well with everyone. No, but truth be told, here's the family I came up with. My dad was a Republican. Okay, he was senior vice president of a commercial insurance company. He was a colonel in the Air Force Reserves. I spent my times on McCord Air Force Base idolizing my father, someone that I deeply love. I saw him talk to me about, and I tell this story so often, I saw him talk about, in the 90s, in the 80s, the value about why we needed to have nuclear weapons to keep our world safe. That was my father. I love him then, and I still love him to this day. My mother, on the other hand, is a Green Party member. Okay? My mother would take me to protest growing up as a kid. I protested the Iran-Contra scandal defiantly because I wanted to be home playing with my toys, okay? And I love her to death. She would get arrested, this is not an exaggeration, at the Nevada nuclear test sites, protesting nuclear weapons, okay? Thank you. I will let her know. In that vein, I would sit there, and this is no kidding. I had this thought as a child, because it's real interesting with two people you deeply love, right? And in this conversation, it's like, why are you getting arrested? Why are you in this space? It's like, well, I really believe we need to have less nuclear weapons to make our world safe. When I talk to my dad, why do you want nuclear weapons? Believe we need to have nuclear weapons to keep our world safe, right? Two people that you deeply love want the same end goal. They're going about it in different ways. And so we have a society that really we want to demonize each other about the way we want to get to a common value. And this goes on all the time. Representative Scouten is here, shaking her head yes, because we both served in the legislature together, where we would demonize each other every 2 years in elections and saying, boy, those Republicans want to have bad schools. Boy, those Democrats want to have bad schools. Now, actually, Rep. Scouten did want to have bad schools. That's why we had to get rid of her. But the truth is, jokes aside, everybody really does want good schools. And they want to go about it in different ways. And again, it's kind of a societal issue we're trying to work through, and that's the way I take this role. Whereas you may not have voted for me, but the way that we take this office, it has to be based on the rule of law and the foundational principles, the stuff that we as Democrats and Republicans, when we were in school, were taught as foundational principles of democracy. And if we uphold that, they may not like the outcome of what we're doing, but hopefully they have trust in the decision process that we're making to get from point A to point B, because I really believe it protects all of us, not just Democrats or Republicans.
Let's talk a little bit about one of the most interesting cases I think you've filed, the Tariffs case. So you and Oregon was the lead counsel here in the Court of International Trade, for those of you who've never litigated tariff cases or other kinds of international trade matters. And in fact, Dan and one of his associates actually appeared there. And you can hear, there's audio on the internet of their hearing before the Court of International Trade in New York, challenging the president's supposed unfettered authority to set and remove and modify and do whatever he wants to on tariffs, because Congress actually has authority and has passed statutes about how about the president's role in tariffs. And the allegations were, and the court agreed with Dan, that the president was abusing his authority and that his actions were invalid until it was set aside by at least for the time being, by a higher court. So tell us about that case a little bit.
Yeah, and this is a case that will be in the news next week because we are traveling back to Washington, D.C. on Wednesday for a hearing on Thursday in the federal circuit on this case, on the merits.
This is the appeal, right? This is the appeal of the case that you won before a 3-judge panel of the Court of International Trade.
Yeah, so it's a little bit unusual. It's one of 2 cases that all the AGs have filed that has a ruling on the merits so far. So that's kind of where we got. This started in Oregon, and it started in Corvallis, Oregon, which is where I live. And
It's part of your consumer protection practice.
Yeah, that's exactly right. So there's certain issues you're looking out for all Oregonians. And if you think about economics, basic economics are pretty simple. Tariffs, the majority of those are passed down to us as consumers. That's just the way it works. Most of these businesses are not going to absorb the tariffs. They increase the prices that we all pay. It was impacting businesses in Oregon. And so it started out with the simple question, can they do that? And that's how a lot of these things start. And as you astutely noted, there are very few people in any Department of Justice office in a state level that have a background in trade law. It's just not something you normally engage in. And so it started off with this, and I went to our special counsel, and we started having conversations, can you do this? I was doing my own research, because I like to be a lawyer sometimes, you know? It's not always business. And so we're working through this together as a team, and we started moving different lawyers in, and we said, this is interesting. This is the first time any president has ever used this law to implement tariffs. They'd use a predecessor law, ton of history, but they'd never used this law. In fact, Trump had used an entirely different law that Congress intended to do tariffs, right? And again, if you look at the Constitution, for those of you who remember that, Congress is the only branch of government that is talked about with respect to the duties to do tariffs, right? Congress delegates power to the president and then puts sideboards on that, and that's effectively the case. And they were using a statute, a very different statute, to then implement tariffs. And so that's where this really came about. And we started coalescing, we started drafting a complaint. Oregon is a direct importer, so we think about standing. And so we direct import goods, and so we started talking about that in our complaint. And then we started, pitching this case to other attorneys general across the country. And some of them were looking at it. We were really far down the tracks, and so we were able to partner with Arizona and a few others. And then we filed the case. This was a unique one that we filed in New York. And I'm a big fan of backwards timelines, and we're filing Tuesday. But the reality, you want to pull the curtains back. We were still waiting to get approved to actually practice in that court because there were no attorneys in any Democratic Attorney General office that were certified to practice in the International Court of Trade. And
have to be admitted to practice there.
The day before, the day before they let us in, and boy, we got it filed on time.
That's great. That's a great case. Oregon's also party in many of the funding cases that you talked about. Which are some of the most important ones here? They involve research, education, highways, all sorts of programs, mental health, environmental protection, and on and on. Tell us about a couple of those funding cases that are particularly important, you think, to Oregonians.
And if I pick one of them, someone's going to be upset in this room because they like another one better. So if there's someone from OHSU here, and I don't pick the research case, and then I've got like NOAA on the coast, right? And the fisheries, it's like it goes on. I think I classify these in a couple different directions. Some of them are funding that's was allocated by Congress is going out, moving into our communities, and it's a whole host of things. When it first started, within the first couple of days, it was a overall federal funding freeze. Even in the Department of Justice, we have the Child Support Division. A lot of people don't think about that. A really incredible role that we play at the Oregon Department of Justice to make sure that parents have child support in their hands, in their bank accounts. We rely on federal match dollars every month coming into our account to manage cash flow. That portal had been shut down by the federal government during that first week in the presidential administration. This was one small area across all of state government in that interaction between federal government. People were incredibly disturbed, as they should be, as you're trying to administer essential services to Oregonians. So that was very shocking, because things like that don't go on. And so that was an incredibly important case, a universal funding freeze that we were working on, and that's in one area. You now have this new battle, terms and conditions is something you'll hear. So as the federal government is going through their contracts with the state, grants, whatever that is coming in, there are terms and conditions that they are adding to the funding. And we have to review those and say, are those consistent with Oregon law? Can we sign those terms and conditions? And sometimes there are cases, and this happened in the first Trump administration, where they're saying, hey, because you are a sanctuary state,
Right.
we are not going to give you certain funding. And in that case, it was public safety funding that went to local public safety entities. And you just simply can't do that. Oregon had a case at that time. It was quickly ruled that they had overstepped their bounds.
And we have a statute on that.
Yeah.
And there are also conditions such as taking certain actions regarding undocumented immigrants. And so you're involved in a number of those cases. My question, the deeper sort of question about these funding cases is, this is great in the near term. And you can, in a lot of these cases, you have a much stronger case saying, oh, this money that was already appropriated by Congress, it was already put in the grant, and you just don't want to cut the check, and getting a court to say, yeah, you can't do that, government. But aren't a lot of these going to be closed out by the appropriations bills that are going through Congress right now? And what's going to happen in the longer run? Aren't they going to zero out some of these grants and programs that we rely upon and that are subject to these lawsuits?
Well, you make an assumption there that Congress is going to act that way, right? Which gets back to my original point, right?
Right.
Decisions made in the dark about how they're impacting us on a daily basis. What is the Attorney's General role right now? Is to make sure we follow the public process. Okay, we have elections, and if the citizens of America want to go a given direction, that's the way our democracy was designed. However, I believe if these decisions are made properly in the proper channels, we will have an opportunity for public input, and these decisions will not occur. Now I'm going to play my own devil's advocate.
Right.
I'm not a big fan of the most recent bill, which I think is an incredible, big problem for society and like essential services.
But it's not
that we
the
pass.
appropriations bill. It's reconciliation.
It is a reconciliation bill. So what I want to do is force the conversation to Congress, because that is the way that our Constitution was really designed to act in terms of spending, the power of the purse. We always talk about that. And that is what I believe the fundamental role is. And then it's up to all of us to then go actively communicate through those channels to make sure that those decisions are being made for the right reasons. But again, elections are incredibly important, and you bring up a really good point. If Congress chooses to act, and they do it legally, right, and constitutionally, they absolutely can. Now, with that said, even though the bill that most recently passed that cuts Medicaid funding and the way we fund Medicaid here in Oregon, that bill, we look at that. Legislators, have been there. Sometimes they pass bills that are unconstitutional. And you target, right? The way that the federal government right now is targeting Planned Parenthood is a real problem. And so the way that you pass bills is not always constitutional. I also believe it is a role of attorneys general to make sure that we're holding the line when Congress acts unconstitutionally too.
Right. Yeah, very good. That brings up a question about sort of Amikas participation, because one could certainly argue that the administration is targeting universities like Harvard and Columbia and other ones, and is targeting law firms like Perkins Coie and a whole bunch of other ones. And are the AGs participating? Are we participating? Are you participating on our behalf as a amici in some of these cases?
We have participated in like there's been some letters that have been sent. There's been some Amikas on the various different things. Not all of them are we participating in, but the ones where we have a direct, clear line of sight.
And again, the argument there is going to be the argument you're talking about, is you're doing this the wrong way. You can't, based on claims of anti-Semitism, defund hundreds of millions of dollars for cancer research at this particular university, or things like that.
Exactly. Planned Parenthood, they are an advocacy organization. Right. You do not get to target someone in America based on their advocacy. That's not American.
Right. Talk a little bit about what's known as the shadow docket. A lot of these decisions that we're getting from the Supreme Court right now are not based on briefs and arguments on the merits. They are injunctions being appealed from lower federal courts, and the Supreme Court is deciding these super critical issues, and maybe not deciding them forever, but they're certainly probably tipping their hand with unsigned orders with no explanation of why they reached this particular result.
And this is, there's a lot of litigation going on. First off, let's just take a few steps back. Currently we're at 33 cases. That number is most assuredly going to increase. You have, and that's just attorneys general, right? And each state's involved in a different level, depending on the harm and the impact and the way they view the world. There are more than, I think, 300 total lawsuits by other parties as well. So just kind
cities
of
and counties and Planned Parenthood, lots of
nonprofits, you
nonprofits,
name it,
sure.
right? So it's a really broad set of body of work that's moving through our courts right now. A lot of the early decisions, we want to think about that. Remember, only 2 of the AG things have decisions on the merits. So you have a lot of procedural things, we talk about injunctions, other things like that, that are trickling up in the court on kind of this docket that has a little bit, I think we've called it the shadow docket, but it really just is a way that there's just less clarity into what really is going on there. And there you can argue that both ways, right? You can argue that in a transparency mindset. You can argue that in, hey, we're trying to get immediate action to disputes that have impact in the moment, right? And so people can view that differently, but a lot of these decisions that are getting some of the headlines are moving through this process that does have a little less transparency. And you can start to argue on these issues that have more critical import across, on the scope and the tools that the judiciary has, shouldn't we have a little bit more transparency, a little bit more thought in why those decisions were made?
And the administration is seeking relief from the Supreme Court or from appellate courts when they don't like what the district court ruled, and a lot of these, and particularly the funding cases, but I think this probably relates to other cases as well. You can't unscramble the egg. If we're defunding USAID or Head Start or a number of other things like that, 3 years later, eventually the states win, and they say, well, you shouldn't have done that. Well, rebuilding that is going to be virtually impossible, right?
So this is a really good point. We talk about all of these cases, so we'll just focus on the ones we're engaged in. 16 of the 33 cases that we're involved in right now have received what we call a preliminary injunction. And for the non-lawyers in the room, that effectively means that you had a judge that ruled, hey, you're probably going to win on this case. That's actually one of the thresholds, likely to win, right? The second part, and kind of what you're getting to, is the irreparable harm that is caused in there. And so some of these preliminary injunction decisions do not have a universal injunction, or making those standards a little bit tighter. What it effectively do is puts the burden on the government, right? And I always think about federal employment. You can move forward with your federal employment decisions, like in that education case. However, if you're wrong, you then have to make it right on the back end. So it kind of shifts that burden in a way, and that's the way I try and rationalize it in my head of how they're thinking about the world.
One of the cases that you're involved in, I think, with an Amikas brief, supports the concept of states' autonomy. You filed a brief in the California challenge to the Trump administration trying to get rid of their clean vehicle program. Why did you get involved in that, and how do you think that's going to play out?
So this was actually pretty early on. It was very interesting before you take office, and actually before Trump took office, there's a lot of pending cases that are already going on. And so one of these things that you do is you say, as you switch the leadership in the federal Department of Justice, how is that going to change their pending cases? So we had some firearm cases where the ATF had made some rule decision, and you had Republican attorneys general challenging those rules. And we knew that in a transition of an administration, the folks actually fighting that would just kind of tone down. So who was going to step in and take some of those roles? And so we did that very early on before even the administration change had occurred. This was a very similar situation where we have admission standards. We are very tied to California in the way we think about emissions, and there's freedom in the ability, and this has been challenged prior to Trump as people are really attacking this, where we want the freedom in our states to be able to set vehicle emission controls and kind of in that autonomy. And so that was being challenged in California, some of their rules. We are directly tied and have a direct Oregon nexus, not only just in values of the environment, but having the flexibility as a state to set that to the level that we believe appropriate.
To seem to me that ought to be a case that some Republican AGs might be interested in, just because they want to preserve their state, or ought to want to preserve their state's autonomy from the federal government, because there may be a Democratic administration in the future, and they'd want to protect it there too.
You know, and again, it gets back to sticking your neck out.
Yeah.
Right. When you've got this in this dynamic in a very political environment, which is not always sanitized, but also the other thing, and I mentioned this to you, and I'll just have fun right now. I was on a call with it was Democratic attorneys general, some Republican attorneys general. We're looking at the portfolio of investments for an association that were crashing because of the tariffs, and in that conversation, right, and you had one of the Republican attorneys general who shall remain nameless, said at the time, well, I really wish Democrats would discover the non-delegation doctrine, which is, let me translate that for you, which is basically like, hey, could you please file a lawsuit using the non-delegation doctrine to stop the tariffs? That's what was effectively being said in that conversation. And so you have this situation, and I say that because if we had, which we actually did do, in that conversation, it is a free riding effect, where in some of this of forcing the rule of law, Republicans are able to not piss off their base, right, but still free ride off of the efforts
They like
of
the
Democratic
result, but they don't
AGs.
want to be associated with the lawsuit.
That's exactly right.
Yeah, that's a really good point. So how is this all going to play out, Dan? I think I've already told you, and you can take it to the bank, that you're going to win the Birthright Citizenship case. And where does it go from there? The tariff case, maybe you win the tariff case. But what I'm concerned about these funding cases. What's the inside word? And you could speak candidly with this small group here. I'm sure everybody will keep it confidential. What are your stronger and what are your weaker cases? Let's put it that way. You can do that. You don't have to say the percentages.
Would you have sustained that objection over that question?
Overruled.
But like in seriousness, into the broader question, what's going to happen in the world?
Some of these, let me just step back just a second. Yeah. Some of these are important things to bring, even if you're going to lose. Yes. Some of them are cases that can go forward and be litigated for some years to come, and who knows? Maybe if Congress changes hands and there's legislation or other things happen, maybe some of them go through the whole 4 years of this administration and you preserve something from being totally dismantled. So there are different ways in which you can win, but just give us a sense of that.
So the first thing I would say, like, as we think about the prospect of all the cases and what's to come in terms of things that we're not anticipating or lawsuits that we may file or outcomes of cases. When I was in private practice and we were, on the precipice of going to trial, well, you'd always talk about the pluses and minuses, the weaknesses, the risks, all of those things with your clients, fully informed. But then I would always end with the one thing that is predictable is that human behavior is unpredictable, especially in a jury context. And I think that's kind of the world we operate as you start moving these cases through the court systems. The one thing that we can't underappreciate is the ecosystem that we operate within. So every case we bring in is going to be based on sound legal philosophy. We're not filing cases that we can't walk into a courtroom with a straight face and argue, in that face. They are values driven. So sometimes we might think, hey, the courts are moving a different direction, and we might lose this case, but it's values-driven, and it's a solid legal argument.
It's values-driven factually and legally.
Yes, exactly.
We're not going to try, and we know this is a loser, but maybe we'll confuse the judge or something. But,
right.
But easy to
That's
do.
Very, but in that space, you have to think about what is that broader ecosystem. Yeah. So let's just take tariff case, for example, because we were talking about it. Congress has delegated some authority, right? Congress, I don't think that the president was going to use the International Emergency Economic Powers Act to implement tariffs because no president had ever done it. Yeah. If a court gives Congress that clarity, what does then Congress do? Right? IEEPA was a creation out of President Nixon's overuse of executive powers. It wasn't just President Nixon. There were other presidents that were actually
Democratic as well as
abusing.
Republican.
I just want to make that really clear and not blame anyone, although people love to blame Nixon. But there were plenty of people kind of exceeding their authority, and Congress reacted. I think you could find a very similar thing in some of the cases that get brought up. You will see a reaction to kind of curb, because hopefully in a democracy we really do value that thing that we were all taught, co-equal branches of government. president. And I think over time, I think we start to move back to those values because they are so ingrained in us as Americans.
Right, so maybe you give a little backbone to Congress on some of these things.
Or just clarity about the weaknesses,
or just clarity,
right?
Right. The fact that somebody actually tried to do this. And there are certain many statutes that give presidents and governors, for that matter, substantial authority in emergencies. And we litigated this, in many cases came to the Oregon Supreme Court during the pandemic. Does the governor have the authority to do this or that or the other thing? And I think getting some clarity there, but importantly for the courts, there is a line. Yeah. No, we're not. Yes, we're going to defer to the president or to the governor in many of these circumstances, but not in everything. And there is a line in which we're going to say, no, this is not an emergency. Yeah, or this is not an invasion by a foreign power just because there are some Venezuelans who happen to be members of the same gang who ended up here.
It's so dynamic too, right? So when emergency orders were initially done, there's the act that creates the ability for the president to do emergency orders, and Congress can override those, right, through a resolution. And when that was first passed, you couldn't veto that, right? That changed over time. So a lot of these laws get set up and then some small thing changes later on. And now if you want to override an emergency order, and we do want to have our executives to have flexible powers with emergency powers. That's actually important to have an executive that can respond in the moment and be able to declare an emergency and look at the facts and do that. You want that flexibility.
But we do know, going back to Nixon, that they have to, if Congress appropriates the money, they're supposed to spend that money.
That's right. But in the emergency power context, right? It wasn't vetoable, right? So Congress overrides the emergency. Now it is. So now you have to have a veto-proof majority to be able to stop an emergency order, right? And now think about Congress. When is the last time that has happened and you've got partisan politics the way it is? So this ecosystem has changed in a very dramatic way.
Right.
And so that's why I think getting clarity can help us get better tools for the government that we want.
Yeah, that's great. And you folks are an important part of the ecosystem. We are now at about 1 o'clock, and this is a time when we're going to take questions from the audience, City Club members only. And so if you have a question, Sam is the man with the microphone, the Dr. Phil of the City Club, and he's gonna.
And let's talk about Sam for a moment. Sam made sure that I didn't. You see how many questions that were asked today? You know how many of these I knew? Sam wouldn't let that happen. He wanted to catch me by surprise. Joke's on you, Sam.
Right, our Zoom call, I started to say, well, Dan, we're going to ask you this, and Sam says, no. We want it to be improv.
That's right. Right. Kevin Downing, City Club member. So you believe in the rule of law, but I understand the president doesn't necessarily. We still have TikTok, even though there's a law banning its use. So what happens after we get to the courts and the administration slow walks, defies, ignores judges' orders?
So what I try and do is focus on what has occurred so far. Now, and I'll get to the specific answer, but I want to give people a little bit of clarity. We've had a lot of rulings against the Trump administration so far. And there have been some cases, especially when you're thinking about immigrants' rights, ICE and some of those, like you can get into some very gray areas, and I would sit here and say that I think that there have been some malicious uses in the way that they have not followed those orders. But for the most part, in a lot of our other funding cases and a lot of other rights cases, the federal government is following the court's orders under those circumstances when we have orders that are very black and white. And so that is something, just as you're thinking about the whole context, that is where we are. I don't have any indication, at least the cases that the state is involved in, that we're moving forward with, that they are going to do anything other than follow that. If there are situations where the federal government chooses not to follow the Supreme Court, there are different avenues of contempt, civil contempt, in ways that you can hold the administration accountable. It's not that you're going to put the president in jail, right? But you can hold the administrators of each agency accountable in a way where it does include imprisonment in those ways, or not imprisonment, but putting people in jail in the civil contempt context. So there are, and here's the thing, We don't ever want to get to that space. I'm operating in a hope that that never happens. Those tools are available to us, and there's even more creative tools above and beyond that. But right now, in the moment, I stay in a space of the orders that we have in a place that the state is a part of, they are being complied with.
Carla Kelly, City Club member. We are 6 months into this presidency, and the amount of legal work and cases it's overwhelming. As you look ahead at if there's another 3.5 years of this, where do you see this going? Is there planning going on for the long term instead of, in addition to the immediate responses that have had to be made?
Yeah, and I think that's one of the frustrating things about this role is because you are reactive, right? If I have to file a lawsuit, if we have the Department of Justice have to file a lawsuit, we are being reactive to something that has already occurred. And that's a frustration. But it's an essential part of the tools that we have. We have a legislature that has its own set of tools. We have a federal delegation that has its sets of tools, and we're all working in coordination together. I think one of the things that we have to do as a society, right, is talk about the world that we want to live in, and talk to voters and talk to people in our communities about what we believe America is and what we believe Oregon can be moving forward. And if we're not doing that and we're only being reactive, we are not focusing on solving kind of our long-term systemic issues. And that is a directional shift. And I'm a Democrat, right? And I will tell you that I have felt probably for the past 8 years that we've been running against things and not always articulating what we're running for. And I think that we have to pivotally shift the way we think about that. And that's obviously a much longer conversation.
Win Wakala, City Club member, and a very optimistic person. Is there any way that the Drump could be declared mentally incompetent and not able to put through any more of this BS?
I mean, there's some that would love to declare me mentally incompetent, and of course there are constitutional provisions and things that you can go down different avenues. I don't think we're in a space where that is there's any factual basis to start moving in that direction. Of course, we could all point to factual things if I get on Twitter very quickly. There's all sorts of things are said there, but I think there's strong foundational sideboards to make sure that those things are being done appropriately.
Hi, Sharon Robbins, City Club member. I think that you've made it clear there's a lot of different judicial philosophies that are at play, but I'm just wondering, regardless of your judicial philosophy, is there a reaction that you're sensing from judges about just the level of professionalism that's coming into the courtrooms with respect to the briefs that are being filed, how they're written, the ability of the government attorneys to answer basic questions for judges? And do you think that concern would also be there at the Supreme Court if people came into the court as unprepared as they seem in a lot of these other appellate and district courts that they're appearing?
Well, there's a lot to that question because what I will say is that each judge has a different temperament. And we've seen some judges be very vocal about their opinions and the strength of cases that are being defended. Birthright Citizenship was a wonderful example of that. The judge gave us wonderful, powerful quotes to kind of point out the silliness of why we even have to bring that lawsuit. And then you have others that are more measured in the way that they are proceeding in those dynamics. What I will say is the cases that we have been involved in, I will say that the Trump administration's lawyers have been professional in their demeanor to the court, right? It doesn't mean that judge sits there and looks at it and say, boys, those are the best arguments I've heard today, right? I mean, that's a reality that we get into. I think it is very illustrative that you have the Chief Justice of the United States that has spoken out about some of the tactics attacking the independence of our judiciary. And I've spent more time in my life in the past 6 months talking about the importance of an independent judiciary than I have my entire life. And it is a very scary place to be, and I believe judges feel this. It is a scary place to be in society, whether you're a Democrat or Republican, to have Congress and an executive branch attacking a core essential function of our democracy, something that is a hallmark of all democracies across the world, and that people strive to obtain. And we are in a moment in time where our politicians are trying to attack that because they don't like the decisions that are being made. And Democrats have done it too. FDR wanted to expand the Supreme Court. Biden wanted to expand the Supreme Court, things that I don't feel comfortable with. And I think so we got to own our own feelings on both sides of these things. But it's a very concerning moment.
Yeah, let me just add a little bit about why the Democrats are winning so many of these cases. It's because these things have not been thought through at all. And in the introduction, I spent some time at the U.S. Department of Justice, and the Office of Legal Counsel, since 1962, has been in charge of vetting all executive orders. And it was because Kennedy issued an executive order saying everything has to go be reviewed by my brother. But that's the words of it. But that person, the Attorney General, delegates it to the Office of Legal Counsel. These are the smartest lawyers in the country, bar none. And they would go back to the White House and say, what are the tell us all the facts that are the basis for this executive order you want to have, you want to sign. And then they would vet those, and they say, well, you haven't established that, and you haven't established that. And then they would look at the legal claims. Based on those facts, what legal authority does the president have to assert that what he or she is trying to do is valid under the Constitution and the statutes? And that has now been completely removed from the Justice Department. It's essentially run by White House counsel in the Trump administration. Actually, after a lot of kerfuffle, they now at least send them over to the Office of Legal Counsel, but they don't review them. So when, in the old days, when somebody would challenge an executive order, there would be a brief that had been essentially worked out and a long legal memo explaining why this executive order, what the facts it's based on, the legal theories, and why it works, why the president does have this authority, and they don't have that. So they don't have any briefs for them. When they go into court, they have to do the research and sort of make it up as they're going along. That's one of the reasons the administration has lost so many of these cases, particularly at the trial court level.
Steve Griffith, City Club member. A number of these cases involve statutes which give the president the power to declare an emergency or to do certain things when the president determines that there's an emergency. Do you think that we will see a case law developing as to what does or does not constitute an emergency? Otherwise, the president can just say there's an emergency, and I'd be very interested whether you think that will come in the future.
And so right now, they do involve the emergency, the declaration of an emergency. And then let's go to the tariffs as the one perfect example, because I think that's a perfect nexus. There's the law that allows the president to declare an emergency, right? And then there is the law that grants the powers for the president to use. So, and that's the IEPA in this circumstance. In our lawsuits, we are not challenging any of the authority that the president has to declare an emergency. What we are doing is challenging his use of IEPA pursuant to the declaration. So to get access to the powers in IEPA, you have to have declared an emergency. And then within IEPA, there's certain requirements that have to be tethered at that point. A, does IEPA even grant you the authority to use tariffs, right? So that's part of the argument, right? For the balance of trade issue, there's actually a separate statute that Congress enacted in this historical recitation of curbing executive power, specifically putting safeguards and sideboards when the president does choose to implement tariffs for a balance of trade issue, right? And the reason they do that is to protect our economy, protect our businesses. We actually want predictability for our businesses. You want to have factual findings. It should be very thoughtful. You shouldn't just do it overnight. in the middle of commerce, in the middle of, as we're trying to engage in the community. So the first part of our argument is you just don't have the authority to do that. Yeah, you've granted emergency order. Yeah, you're trying to use your executive powers under AIPA, but AIPA doesn't allow you to do that in a balance of trade issue. The second, the two other emergency orders that he had to deal with the fentanyl crisis. And so the fentanyl crisis coming from Canada, coming from Mexico, coming from China. And then the argument in that case is the tariffs that you're using, first, you can't do tariffs. Number two, the second part is if you can do tariffs, it's not tied to the crisis you're trying to address. And that is the other part of the argument. So as you'll kind of see in the way that we lay that out, where we're not really attacking the executive order, because there is a lot of case law, and frankly, there's a lot of public good, again, in having your executive, whether it's your governor or whether it's your president, to be able to react in the moment to emergencies as they exist, right? I mean, we do want to have that flexibility just for a lot of good societal public policy reasons. So at the current moment, we're not attacking that because I don't believe that is as strong of an argument.
Do we have time for two more quick questions, Sam?
We do.
Or if there are more people there, I see two and maybe three. Let's do two.
Shoshana Baird, City Club member. I recall in some of this discussion we've been talking about how, while largely impactful, sometimes frustratingly legally obvious these cases can seem. Are there specific cases that you feel like present a really, from a lawyer nerd perspective, an exciting legal question that you're looking forward to exploring or getting a clear resolution of?
They are all incredibly interesting for very different reasons, and you could nerd out on all of them, like honestly. But the one that I actually find fundamentally very interesting is, and I'll just keep going to the Tariffs case, just because I actually do believe this is one of the most interesting ones in the nation right now. I think that this is quickly on the way to the Supreme Court, and it's involving what we call the major questions doctrine. And it's involving the non-delegation doctrine in some of these spaces. Now, history of that for like non-lawyers, these are often principles that Republican attorneys general have been developing throughout the years, and now we are using those same principles in our own case moving forward. So it's this very sharp shift in using some of these foundational principles moving forward, and I think the way that the judges rule on this is going to be incredibly informative.
And this would be Dan's first Supreme Court argument when he takes it up there. So mark my words.
As we, Danelle Stevens, a new City Club member. As we move towards a police state, it seems, with ICE grabbing citizens off the streets, wearing masks, and terrifying a large group of our population, what is the role of the Attorney Generals?
Yeah, and so this is a very good question because we all have a different role in this issue. So when you think about Congress right now, so you have Senator Wyden is advancing bills in Congress to kind of curb frankly mirroring some laws that are already in existence in Oregon. But again, Oregon laws cannot control federal law enforcement. So Senator Wyden is working on various policies, and we think you were talking a little bit about masking. You have other issues that are more state-oriented. So we have our sanctuary status laws. So one of the things that we have done before I even took office and started moving forward, we started partnering with law enforcement to really get a common understanding of what our sanctuary status laws are, how do they exist. Now, truth of the matter is, our laws have existed for decades, and they've peacefully coexisted with multiple presidential administrations. Our law enforcement knows how to operate and keep our communities safe with the laws that we have on the books right now. In that same space, we have a bias hotline and a sanctuary status hotline that we get calls into. It's not necessarily an enforcement tool, but it's a way for us to gather data to kind of really understand and better provide information back to law enforcement about what we're seeing in the community. Now, when people's rights are being violated, so ICE is a federal law enforcement agency, right? So they are funded federally. They're operating and enforcing federal statutes. And they are able to go through community. Now, when they do so, they have to follow the United States Constitution. And that is with the crux of the question where you're getting at. Under those circumstances, there's different angles. A lot of people have personal claims that they can bring. Okay, then there's resource questions for those folks to be able to bring those claims. In Southern California, there is a current case that is being brought after they gathered facts. Remember, you're building the case, and it's been brought in Southern California and some of these are being brought by nonprofit organizations. Some of them are being brought in-house. The lawsuit in Southern California is that it's based on more violation of rights in a broader sense of targeting certain populations based upon the color of their skin. And that is being brought in Southern California. You've had amicus briefs filed in those cases, so we filed an amicus brief in those cases, really looking at, okay, you need to follow the United States Constitution as you are enforcing the federal law under your responsibility. And so those are the other battles that are going on in that space. We are taking action on funding issues and making sure that we are not being discriminated based upon Oregon laws on our sanctuary status, birthright citizenship, and there's a whole bunch of tangential areas. And then the state legislature has its own set of tools and responsibilities in that. So you can kind of see there's an ecosystem of people working together in this space.
Thank you for that. This concludes our program today. You can tell, I think the lawyers in the room are probably wanting to apply for CLE credit for this event. It's been educational for all of us, and I know if you're like me, you've appreciated the importance of having an AG who's willing to vindicate constitutional rights for us all. So let me have a thank you to Justice Balmer for conducting this interview, and to AG Rayfield.
Thanks, Dan.
And a special thanks again to the Miller, Nash, and Tonkon Torp firms for sponsoring this event tonight. And to our season sponsors, AARP Oregon and Fight Against Sex Trafficking. And I'm going to ask you, if you would, to let Attorney General Rayfield escape to another meeting before you grab him. And if you have questions, Justice Balmer's going to be able to answer those.
Justice Balmer's retired, so he doesn't have anywhere to go.
All right. Thank you so much for attending
Thanks
today.
a lot. That was a lot of fun. Yeah.